seated.
Good afternoon, everybody. Welcome to an abbreviated session of the Appeals Court. The case that we're going to hear is 22P0463, Maureen and George Butler against Nils Johnson and others. We are your panel for this one hearing. My pleasure. I'm John Englander, and my pleasure to sit with Justice. Oh my God, Justice Grant and Justice Brennan. My goodness, that was a senior moment. I apologize. You can be assured that we've read the briefs and we've read all the materials carefully. There's no need to go over facts unless you think they're critical to your arguments. Instead, get right into it. With that, Mr. Rosenblum, is that right? You may proceed.
Good afternoon, members of the panel. May it please the court. I'm James Rosenblum. I represent the plaintiffs and appellants in this case, Maureen Butler and George Butler. Can you hear me okay with this microphone? Thank you. Your Honors, as you know from the materials, this case concerns the Mattapoisett Inn under the ownership of and operation of Nils Johnson and his company, Vintage 13 LLC. My clients, the Butlers, both reside and also have a business and rental property adjacent to the inn. Your Honors, there were a number of errors in the lower court decision that I'd like to bring up here. Number one was the lower court trying to exclude the application of the Mass DEP noise and air pollution policy because he claimed that the gatherings in the inn were public gatherings. This would have if this were the law, this would have a pernicious effect because any gatherings inside a private inn or bar or whatsoever would be exempt from this Massachusetts policy. The aim of the
Was the inn a place of public accommodation within the meaning of the anti-discrimination laws?
I'm not sure of the answer to that, Your Honor.
Why do they call it a pub?
Well, it's called an inn, Your Honor.
Well, but a bar is called a pub sometimes. Why? Do you know?
I assume it comes from the word public, Your Honor. Yes. However, in this case, this is not the purpose of the regulations. In some senses, you can say pub comes from the word public, yes. However, in the meaning of the DEP regulations, they're meant to protect the public from obnoxious noises. They're meant to provide an objective standard by which one can measure whether something is bothersome or nuisance or potentially damaging to hearing.
Ask on that. In your brief, you talk about public gatherings like sporting events.
Yes.
Right? So suppose the sporting event is in a domed stadium. Is that a public gathering?
If there's a permit issued for it, I believe it could be.
In terms of the character, because you indicate it's usually an outdoor event, a recurring outdoor event. But
yeah,
if
there's nothing that says it couldn't be indoors, but it has to be a public gathering with a permit issued for it. I think in the context here,
So you're suggesting a permit's issue every time a football team plays in a stadium?
I'm not sure about the specifics about which permits are issued there, but I do believe that that would be much more of what is meant, perhaps, by the Mass DEP regulation and the policy. To have a private inn excluded from that, I think, would be a pernicious policy. This is not the first case, Your Honor, where there's been a private business that has operated in such a way that there's a claimed nuisance. And I believe the policy is very useful because it provides an objective standard. Of course, testimony is also very useful, and we have some.
So let's just slow down there because, assume that I agree with you. Just assume it.
Sure.
It's not conclusive evidence on either of the issues that you wanted to bring forward in this case, right?
Yes, you are correct, Your Honor.
Either as to non-conforming use or as to a nuisance.
Your Honor, you are correct. It's not conclusive in that it's merely persuasive evidence. However, I would argue that it is very
Persuasive evidence of what?
Of a nuisance, of common law nuisance, Your Honor.
Well, there's nothing in the reg that says that.
There is
Reg
actually
uses the word noise pollution, correct?
there is actually two sections of the reg, Your Honor, and one of them does mention the word nuisance in it. So this is the DEP's definition of kind of what would constitute a nuisance in their eyes. Not a common law nuisance, so it's not binding the court in any way, of course. But I would still contend it's...
Surely it's not the case that any time you're 10 dB over ambient, you've engaged in a nuisance for purposes of common law.
Well, Your Honor, the 10 dB standard has to be, first of all, taking place across a property
Because
line.
then anybody with a lawnmower is engaged in a nuisance. Then anybody with, a loud car, anybody with a motorcycle, they're all engaged in nuisances?
If that sound is measured across the property line, you can say a motorcycle would cause a nuisance, but there's no practical way to bring a lawsuit against somebody who drives by with a motorcycle. If this is a recurring
Suppose your
event...
neighbor has a motorcycle, he starts it up, his driveway is 10 feet from your property line.
If that's a
It's
recurring
going to be
event...
over 10 dB above ambient.
Yeah, as measured across the property line, Your Honor, I believe, yes, you could definitely
That's a
bring...
nuisance?
I believe so. If it's... Increasing 10 decibels above ambient is perceived as a doubling of sound. It's a vast increase in sound. And here we're looking at sound that's actually much more than that, like 8 times the amount of sound. Whereas the expert testified 100 times the sound pressure level. So I believe in the motorcycle example, yes, that could be considered a nuisance, Your Honor.
But we don't have cases about motorcycles, right? I mean,
I don't know, Your Honor.
not usually, anyway.
Yeah.
When the judge made his findings about the decibel levels, was he making those averages based only on the vestibule, after the vestibule was installed in May of 2018, or on an average across all of the data?
I don't know for sure, Your Honor, but from how I read his decision, it seemed to be across all the data. But the average, as I
Does that
said,
make it higher than it is now?
perhaps, Your Honor. The point is you might as well throw out any number because there's no actual way to average it because he didn't even have the data in front of him to average it, nor did he have a methodology.
He didn't even have the data in front of him.
So what was in evidence, Your Honor, was the graphs, right? And you can visually pick out a particular point on the graph. You can say this point is, 60 decibels or 70 decibels. But there are 280,000 data points in this thing because the decibel reader is recorded once per second. That's just, rough estimate over a 2.5-hour period.
I understand your point now, but what he did have was all those graphs. That's data, isn't it?
It's data, but not averageable data, Your Honor. You can't, first of all, even if you were to eyeball it, right, and you say, well, this point is 60 and this point is 50, so the average is 55. First of all, it doesn't even work for decibels because decibels are on a logarithmic scale, so the average would probably be about 58 or 59 rather than 55, the way that the decibels are. Second of all, there's no reason that the court had to go off and try its own acoustical analysis when there was an acoustical expert at trial who made conclusions already.
So you're saying he had to adopt Mr. Comrower's conclusions? He couldn't?
Yes, Your Honor, because there was no contrary acoustical expert at trial. This is acoustical stuff that gets into the expert realm, and that's why we brought the expert.
So if this had been tried before a jury, the judge would have instructed you were bound to accept the expert's testimony?
Yes, Your Honor. As we said before, the conclusion about nuisance...
No, he wouldn't. The jury is not bound to accept anything that they hear. He
My
would not
mistake.
so instruct.
My mistake,
Okay?
Your Honor.
Well, no, but I mean, let's get the law right here so that we're all on the same page.
Okay.
And neither is he required to accept your expert's testimony just because there's no expert on the other side. He listens to the expert testimony and he decides what's credible and what's not. That's what a finder of fact does, right?
Yes, Your Honor. Yes, Your Honor. I don't believe it's his job as a finder of fact, however, to try to average the data, though.
A different point. Whether or not he has the resources in order to be able to average is a different point, which I
Right, Your
take.
Honor. Right.
But aren't you telling us that we, because we have documentary evidence before us consisting of the data, we can set aside the judge's finding and reconsider the data ourselves? How come we can do that when the judge couldn't?
Oh, the judge absolutely could, but I'm not saying that you should or attempt to average the data or anything like that. The judge absolutely could and did look at the documentary evidence, as should the appellate panel. One point about the documentary evidence I wanted to point out on the videos, for example, I wanted to caution the court against trying to draw inferences based on the videos saying, well, it doesn't seem that loud or bothersome when I listen to it on my computer. Because a couple of reasons. One, the microphones used to record the videos were different than the microphones used to record the audio data. The microphones for the audio data were placed on the butler's porch, and they were calibrated and testified to as calibrated. The microphones on the video, we don't know if they're calibrated. It wasn't presented at trial. Basically, they're just there to show what kind of thing was making the noise. It was bands making the noise and not something else. That's principally why those were offered into evidence.
Is the quality or character of the inn's use of the property changed just because the genre of music has changed from Irish music to rhythm and blues?
You might say that. I think in this case there are other ways in which the quality or character differs more significantly than that, which is the amplification of the music as compared to 1967 when the bylaws were enacted, the presence of perhaps 5 to 6 performers as opposed to a single performer there. So there are different ways in which that's more
What do
true.
we do with the judge's finding then that, okay, so the music is amplified now, but the soundproofing is better?
Your Honor, I think that's a facetious argument because we have data from 2018 and 2019 as well as testimony from 2018 and 19 after the vestibule was put in place. The testimony from Kelly Selleck and from Mr. Mendel, who were both renters at the Butler's property, that was from 2018, 2019, after the vestibule was put in place.
Well,
So,
hold on. First of all, how much of the data predates the soundproofing versus postdates the soundproofing? What's the cutoff date on that?
so 2012, Mr. Johnson took over management of the inn. 2014, he took over ownership. 2018, the vestibule was put into place, and then 2021, I think, was the trial. So about, at least 2/3 of it was before, and about 1/3 afterwards, maybe.
2/3 of the data from the butler's porch predates the putting in the vestibule.
That's about right, Your Honor.
Do we have the exact date do we have a cutoff date so that if we're looking at the data, we could?
Well, I do state in the brief which ones are after and which
You understand,
before.
I mean, you're asking us
Yeah.
to declare his findings clearly erroneous, so,
Yes.
okay.
There is, I think, at trial, it was testified spring 2008. I don't know if we got a precise date on that.
2018?
2018, I'm sorry, Your Honor, yes. And I think I don't think there's any recordings that would be ambiguous as to whether they're after or before.
Is there any evidence put in directly asking someone to read the before and after as to whether it was less or the same as the data preceding it? Do you understand my question?
Not really, but I think I get.
Well, then let me see if
Okay.
I can.
Yeah.
Did anyone at trial try to compare the readings from the butler's porch before the vestibule and after the vestibule?
Well, there are different bands playing, and there's different circumstances, but to get to whether the vestibule reduces sound, it absolutely does, Your Honor. There's actually something in evidence about that. It reduces it significantly, assuming the windows and doors are closed, which they're not always closed during performances. But it reduces it by something around 45 decibels. Nevertheless, that's only...
45 decibels?
Yes, that's only when the windows and doors close. That's only A-weighted. It's not considering bass sounds that permeate through the walls. And even with that amount of reduction, the sound is still can reach up to in the 80 decibel range at the butler's property. So that's still significant sound, meaning the sound inside is 120 decibels. And that's after the vestibule.
120 decibels inside sounds like nobody could survive it.
You can survive it, Your Honor.
Testimony from anybody who actually took readings inside that there were 120 decibels of sound inside?
Your Honor, the acoustician Jeffrey Kammerer attended one performance inside and took a reading on his iPhone. In that case, there was only one performer on guitar, and with one performer, it reached up to in the 90s decibels.
Okay. That's a
He
lot.
calculated-
As you might point out, that's 1/8 of 120 decibels.
Yes, he calculated the 120 decibels based on the amount of sound received outside and the
Right.
distance
I saw that testimony.
in between. Yes.
Okay.
Can I say, the judge, if I'm not mistaken, found that your clients essentially, they knew what they were getting into when they bought the property. All right, how can we find that clearly erroneous? I mean, they bought two properties right next to a fairly vibrant restaurant, bar, entertainment place?
Absolutely, Your Honor. Well, for the first 8 years, even the owner of the bar testified that they didn't complain at all. The sound clearly wasn't as bad then. There's other facts in the brief that go to that issue too, including the fact that the lower court judge, did not really address whether it was this loud in 1995 when they moved in. He was focused on the 80s when it may have been more raucous, but it's not relevant to the
Can I just stop you there, because if you...
No, I'm fine,
I
please.
have a real issue with that.
Yeah.
The sound clearly wasn't as bad. Maybe they just had not yet decided to object, because I read evidence today that the sound was less than it was in past years.
Well, thank you for bringing that up, Your Honor. I mean, a couple of issues. One, the sound from the back door was a major issue in the current era. And in Mark Godju's era, he closed off that door after 1989. He wouldn't let patrons exit and enter through the door. So that was a big issue. You can say that they didn't complain, but I mean...
But how does that help you?
There's-
I mean, that suggests that there's less sound as we get farther into the 2000s.
No, the Godju era was 1995 through 2004 is what I'm talking about. It was closed off.
Are you saying that after that they reopened the door?
Yes, Your Honor.
Oh. What was the evidence on that?
There was testimony about it. Mr. Godju and the butlers testified about that. And Mr. Johnson testified, I think, as well.
Testified his door was open? His back door?
He allowed it to be used by patrons. There's also video evidence of patrons exiting and entering there.
Do you mind if I ask a question?
Of course not.
We're past the time. You raised, or your clients raised an issue in the Superior Court that this amounted to an obnoxious noise in violation of the definition in Section 2.2 of the zoning bylaws.
We're not appealing that part.
You're not pressing that now?
No.
Okay,
No.
thank you.
You have anything else? Thank you very much.
Thank you.
We'll hear from Mr., is it Deshays?
Members of the panel, my name is Attorney Mark Deshays, representing Vintage 13 and Nils Johnson. At the outset, I would like to thank the court for indulging in postponing this matter due to my recent medical event. I appreciate the consideration by the court.
Happy to do it.
Your Honor, one of the first questions from the bench was, is this a place of public accommodation? Yes, it is a place of public accommodation. When Mr. Johnson took over the inn in 2012 from the Kinsale Inn, there were a number of renovations that had to be made to the inn. The first renovation that had to be made to the inn was that the front porch at the inn was in rather bad shape. It was in disrepair, needed to be repaired. Because we're in a village district in the quaint part of Mattapoisett Harbor, we had to obtain a special permit. He had been operating the inn from 2012 to 2016 when he made application for the special permit to redo the exterior porch and deck, which is a...
As I understand it, the butlers aren't raising on appeal the issue about the special permit for the porch.
No, they aren't, they're not, Your Honor, but I was getting to the point of a place for public accommodation. When we made that addition to the front, we went to the building commissioner, and the building commissioner said, since you serve meals and beverages on the front porch, you have to make it ADA compliant. It's a place of public accommodation that comes under the state regulations regarding architectural barrier. So to address that issue, yes, we are a place of public accommodation.
Okay. But do you think the judge is right when he concludes that you're operating what is in essence I mean, what's the exact language of the exclusion that he thought applied?
Says that we're,
Another senior moment. This is 2 in half an hour.
I've had those, Your Honor, public gatherings.
It's a public gathering. Yeah, is there any suggestion that the exception for public gatherings was supposed to apply to a business that's running 7 days a week, 365 days a year, and is operating a band 3 days a week or 4?
I could find no definition of that, and in the regulation, it doesn't.
Make this
define
argument
it.
to the judge, or did he come up with it sua sponte?
This is something that the judge raised on his own
Okay.
in his decision.
Because it seems to me your opponent has a pretty good argument that the exception is supposed to be an exception. It's something that's unusual, not something that you would provide an exception for a business operating regularly 52 weeks a year.
It's set forth in a policy statement from the DEP. However, it is not defined. I guess you could say that the Boston Red Sox meet 81 games a year. They operate consistently. Is that a place of a public gathering? Yes.
Point. I don't know what happens with the Red Sox, but they probably were in operation and making loud noises before the zoning laws of Boston went into effect. Anyway, let's assume that the exception doesn't apply and that the DEP standards are 10 dB above ambient is I think the word is, it's noise pollution, right? Isn't that what it says?
It does say that you measure
So if you assume that, now take me through why we shouldn't care for purposes of the judge's determination of whether there's a nuisance or not. We'll start with a nuisance.
You heard my brother talk about data points, that every second is a data point, and that during a 2-hour period of time, there's, I think, 272,000 data points that are compiled and compressed in some kind of computer format to measure decibel levels over a point in time. The judge in his decision looked at and heard testimony on these facts and looked and basically concluded that when you look at it, there may be spikes above the 49 plus 10 decibels of 59, but on average, they come under the 59 decibels and as such are not a nuisance or constitute
On average,
noise.
they come across what time period? See,
The-
there are definitely, I've looked at enough of these in your case. There are extended periods of time where the LEQ, which I don't think is even 50%, as your opponent points out, is above 59, right?
It all depends which ones you were looking at, because their expert testified that once we put into place the vestibule with the sound insulation, the sound dampening glass, on average, and he got a court order to go inside the inn. And as I point out in my brief, he used a sound generating apparatus of his own choosing to blast sounds at the westerly wall and measured that they had a consistent 42 decibel reduction. And that when you open the...
That doesn't help you if he also has data which shows what the sound level is from the porch of your neighbor. And if that sound level is over 59 for some, I'm not talking about a second, for some extended period of time, then Isn't that a violation of the DEP reg?
I think strictly speaking, it would be a violation of the DEP policy for that specific point in time. But like you said, in the original instance, if I started a Harley Davidson in the yard, then I took off, there may have been a sound violation at that particular point in time, and it may have continued as you drove away, but at a certain point in time, it dissipates. These are isolated incidences that happen, and they have decreased dramatically. And
Is your opponent right that under current management, the back door opens and closes a lot? What was the evidence on that?
there was a few videos that were introduced. You have to understand that the side door that is facing the 10-foot wide, these houses are built in the late 1700s, separated by 10 feet in distance. The door on the side was the secondary exit for emergency purposes.
Okay. Is that opened and closed on any regular basis?
Not on a regular basis. Not on a regular basis. Most of the patrons come in through the front of the inn and exit through the front of the inn. Occasionally, individuals will exit, and there was testimony that some people will exit to go out because you cannot smoke within the inn. They'll go out the side door. We can't lock it because it's an egress point for public safety purposes. It's also a place that has our handicap ramp for people with disabilities.
Wait a second, the handicap ramp goes into the side door?
Yes. And that's what was enclosed.
Oh, that's enclosed now by a vestibule?
Yes. At one point in time,
Is that in the 10-foot space?
at that 10-foot is the width at Water Street as it proceeds towards the back of the inn and the parking area. It may expand to 18 feet, 20 feet. It is enough for cars to go in. No two cars could pass at the same time. It's just enough for a public safety vehicle.
In that area, you constructed a handicap access, which,
The handicap access ramp was constructed by the prior operators, the Kinsale Inn. When it was the Mattapoisett Inn operated by Gaudu, it was 2 steps that went down to the driveway.
Can I ask you a question? And I apologize if you already answered it, but I'm still having a hard time getting to how the judge decided to calculate this average and whether that was an appropriate, or how that was an appropriate method to calculate decibel level.
How he calculated it?
Yeah, I mean, the plaintiff's argument is that he kind of did his own math without any real scientific or testimonial basis for it.
Your Honor, Justice Brennan, I don't know how he calculated it. I think I point out in my...
We need to know. I suppose that's, if it's a finding, do we need to know how he arrived at that finding?
I pointed out that he, in my brief, I said, he sat there for 10 days,
Right.
listened, heard both documentary evidence, the videos, the recordings.
Yep.
He heard people testify. He went out, he walked the properties, he looked at it, and they're saying now that he has to have a degree in applied mathematics from MIT. I don't know. This was not a newbie. This was a seasoned jurist. He's been on the bench for 14 years, and he was former corporate counsel for the town of Fall River. He's seen these issues before as being a corporate counsel. I can't say how he did it. I would say, when you say one
Again, that's my
data,
question. If we're to assess error or clear error, don't we have to know what the methodology is, or not? Why do we not need to know the methodology?
Well, the eyeball methodology or dispute has to do with the spikes. It looks to me as though the judge eyeballed the charts and said the spikes, when the doors open, are around, I think he said 83. But then there was testimony from the plaintiff's witness that the number was 59 most of the time. And so,
when you look at the expert report that was accepted into evidence, their expert concluded with the 4 different genres of music that he chose, they were now below 59. Maybe Judge McGuire looked at that number that he's now saying is below 59, looking at some spikes. Maybe that's how he made his mathematical
Right, and my question is...
I don't know.
I understand your position, but I think the plaintiff's position is that requires expert testimony, and there wasn't any here. That the expert didn't testify to an average. You got numbers, and the judge sort of...
Their expert did. He basically, in a graph that's part of the record, basically calculated, and he said that when these windows and doors were open, it just went up 3 decibels more. Not that big logarithmic scale where we had a little bit here and a big amount at the end. I don't know how he calculated it, except to say that he sat there somewhat tortuously, listened to a lot of different things, saw a lot of different things, judged the credibility of the witnesses, visited the property. I think Justice Grant's position is he had some documents in front of him, maybe, sort of like in the old Olympics when take the high and low and average the middles. I don't know. Throw the high and the low out and average the middles.
Was there testimony about any way to average the...
The one piece of evidence that talked about averaging was their expert when he averaged the various different genres of music that he blasted. They went into court, got a court order, said, we want to see what the sound insulation in the wall, the sound dampening glass, if you will, the compartment that compartmentalized from that access door, and then 14 feet later, there's a steel door. He basically went there, he blasted, he actually went outside and set up in triangulated sounds, if you will, at the property line. He's the one who set it up. He's the one who came with some data. He's the one who made the decision. And in that thing said, guess what? It's below 59.
Well, as I point out, though, that's he dealt with that at trial in a way that made sense to me. He said that was a test that I set up, but here we have data from the property line, that on a calibrated instrument.
Yeah, but that was some information prior in time to that measurements being made.
Okay, I think we have it. Judge Grant?
I'm all set.
Any more? Judge Brennan?
Thank you very much.
Thank you very much for coming in, folks.
Thank you.
We will take the matter under advisement, and we are adjourned.
All rise. We'll stand in recess.